Hi, Wendy. Thank you so much for joining us here today.
I'm happy to be here.
Thank you. I am here with Wendy Stephen, Queen's Counsel, Crown Counsel of New Westminster. She has been a lawyer for 38 years, and for the last 20 years, you have specialized in homicide cases. And you have now prosecuted approximately 55 homicide cases to date.
That's right.
That's quite impressive. Thank you very much for being here today. We really appreciate your time in this.
Well, I think it's a wonderful cause that you're doing, and I'm happy to help.
So what we're going to do today is you're gonna help us understand the Crown Counsel's role with a homicide case.
Yes.
And if we may, we just want to maybe start at the beginning, maybe give a brief description of Crown Counsel. What does that mean? And where you come in with the homicide case. Let's start with that.
Okay. So Crown Counsel are all lawyers. You must be a lawyer in British Columbia in order to be Crown Counsel. But Crown Counsel are different than any other lawyer that you'll encounter. If you are in a motor vehicle accident and you hire a lawyer to represent you, or you've had some home renovations go wrong and you've hired a lawyer to represent you in a claim against your plumber or your roofer or whomever, you are the client and your lawyer takes instructions from you. Crown Counsel is fundamentally different. Crown Counsel is basically society's lawyer. So we represent everybody. We represent the victim, we represent the family, we represent witnesses, the police, the accused, and just society at large. So we don't take instructions in the same way that other lawyers take instructions from their client. But our job basically is to do the right thing for everybody. And so our job is to help the court ensure that justice is done, that all of the available relevant evidence is brought before the court that will have a say in what the outcome of the court case is. Now, usually that responsibility is undertaken by making disclosure to the defense, and then the defense lawyer represents the accused. Sometimes the accused is unrepresented, which means that they don't have their own lawyer. So the court has the overriding responsibility of ensuring that they are able to get their points across, but the Crown has a secondary duty to ensure that evidence that might be useful and helpful to the accused be put forward as well. Now, in homicide cases, that's unusual for a person to represent himself or herself, but it does happen. Mm. So that's the overall view of what Crown Counsel does and why we're different than other lawyers. In a homicide case, the role that the Crown plays is the police investigate, a homicide occurs, the police investigate it, and then ultimately brings their investigation to the Crown. The Crown is the entity that decides what charges, if any, will be laid, against whom, and when. Now, the police and the Crown work hand in hand. We often consult with each other. The police, in the course of their investigation, will come to us and say, we're thinking about doing this, or we think we have enough. What do you think? And then the Crown will weigh in at that point. But ultimately, both the police and the Crown are independent entities. And so the police have the full responsibility for investigating. I can't say to them, you must go do X, Y, or Z. And then they bring it to the Crown. And once they put it into the Crown's hands, they no longer have really any more of a say than the victim's family, for example. Crown Counsel generally consult with the police and consult with the family before making major decisions, but ultimately it is up to the Crown to make those decisions. We have the responsibility of doing that through legislation in British Columbia called the Crown Counsel Act. So we decide what charges will be laid, and as I say, against whom and when, and then we take the conduct of the prosecution from that point forward. And we're the ones who the police give all their investigation to. We're the ones that carry out the responsibility of making disclosure to the defense. We do all the court appearances, bail hearings, setting court dates, a preliminary inquiry if there is one, and ultimately the trial. So that is our responsibility, and we carry it out. There's about 500 prosecutors in the province. Not everybody does homicide cases, but the basic procedure is the same, whether it's a shoplifting case or a murder trial. So that's the overall view of it. Now, in my practice has always been to consult with, as I say, the police and the family for the important decisions, not a decision about whether a charge is going to be laid, because that is based on a review of the admissible evidence that the police have been able to gather. So a family may be absolutely certain that they know who is the person responsible for the death of their loved one, and they may well be right. But unless we have admissible evidence that the police have gathered, then the shrewdest hunch in the world won't get us anywhere. So, as I say, the police gather the evidence, and then we take a look at it to ensure its admissibility. There are many, many, many rules of evidence and the law that has to be brought to bear on this. There's all kinds of things like, hearsay, for example. So if, somebody's told somebody who's told somebody, and then that somebody tells the police, that's not good enough. We have to have the original person who saw or heard the accused make shoot the gun or make the stab wounds or whatever it might be. So that's one thing. There can be other things like search warrants being executed. Sometimes the police make a mistake, and it's the Crown's responsibility to look at the documentation to ensure that it's going to pass muster when the court reviews it. And then ultimately we apply the test of whether there's a substantial likelihood of conviction and whether it's in the public interest to prosecute. Those are the twin, the pillars upon which any charge is based. Now, a homicide case is always going to be in the public interest to prosecute. So the real issue is whether there's a substantial likelihood of conviction. And that's a lower test, of course, than what the court will ultimately be required to decide, which is, has the Crown proved this case beyond a reasonable doubt? So the substantial likelihood test is quite a high test, but it's not as high as the test that you would have in court. And the reason we have that is because the police, when they're gathering their evidence, not everything goes as smoothly as we might like it to. And sometimes witnesses are more willing once they get to court. Sometimes they're less willing. And so it's a continuing assessment that we have to do. So even though a charge has been laid by one prosecutor, for example, having looked at the written materials that the police have brought forward, it may well be that something occurs or more information is brought to light or further evidence is gathered, including by the defense lawyer providing information to the Crown, such as there may be a self-defense issue. There may be an issue about drunkenness or intention or something of that sort. So we have to continually assess the case. And that's why sometimes, even though the initial charge was, say, first-degree murder, the Crown will look at the case, will talk to defense counsel, and ultimately decide that it's better to agree to a plea of a lesser charge rather than go ahead to trial on the higher charge. And as I say, that is something that I make a practice of always discussing with the police and with the family, but ultimately it is the Crown's decision to make. And as I say, the input is important, but unfortunately, it's neither the police nor the family have the ultimate say. So that's the responsibility of the Crown.
Right. And when you say plea, so is that a guilty plea then?
Yeah.
Yes. The accused has agreed that instead of a what would we say, a first-degree murder trial, they're going to plead towards a lesser charge,
such as second degree or manslaughter.
And so can you explain the benefits or
sure.
I don't know if the word benefit is the right word, but the reasons why.
The pros and cons.
The pros and cons and why a defendant may plead guilty.
So we have first-degree murder, second-degree murder, and manslaughter. Mm-hmm. Murder is an intentional killing. And manslaughter is a killing that occurs most often in the course of an unlawful act. So the clearest example is if I'm very angry with you for whatever reason, and I take a gun and I put it to your head and I say, I told you I was going to kill you if you did that, and I pulled the trigger. That we can infer is an intentional. I'm making an intentional action. and I'm intending to kill you. I'm intending to kill you because I've taken a gun and pointed it at your head. Manslaughter is often, maybe we're in a fight and I punch you, and I'm not intending to kill you. I'm intending to punch you, but I'm not intending to kill you. But you fall over and you hit your head against the curb of a sidewalk, and you do die. So I would be guilty of manslaughter in that case, but not murder. Murder has a life sentence. There's a mandatory sentence of life in prison for murder, either first or second degree murder. And manslaughter has it's within the complete discretion of the judge. There can be a sentence of anything from what we call a discharge, which is either conditional discharge, which can be you do certain things in a period of probation, and as long as you've done that, then you don't have an actual record as such, up to life in prison as well. And it's usually several years. It's usually sort of in the 7 or 8 years type imprisonment, but it's a finite period, as opposed to life in prison, because in Canada, life in prison actually means life in prison. Eligibility for parole is also set by the judge on murder charges. On first degree, the mandatory period of ineligibility before the person is able to apply for parole is 25 years. For second degree murder, it's set by the judge, but it's a minimum of 10 years and a maximum of 25 years. And there's a whole bunch of things that go into where that would fall on that scale. But at the end of the day, what's important for families to remember is that a murder conviction, as I say, carries a period of life imprisonment, even if the person is eventually released on parole. And parole eligibility only means that they're entitled to apply to the parole board for parole. Doesn't mean they're going to get it. So if they do get parole, they are always under the control of the parole board for the rest of their lives. There's never an end to the sentence. So they're never completely free ever again. So sometimes we'll hear on the news that so-and-so was convicted of first degree murder and got 25 years. That's actually inaccurate. What they got was a period of life imprisonment with no ability to apply for parole for 25 years. So now I've forgotten what the question was that you actually asked.
What would be the benefit to the accused to plead guilty?
All right. So when everybody's preparing for trial, there's almost always a time when the Crown and the defense have some discussion about whether there's an ability to resolve the case without going to trial. That usually involves a plea to something lesser than the charge laid, but not always. Some people, somebody who's committed a homicide can be extremely remorseful and just simply want to accept responsibility for what he or she did. So there are times when people are charged with first degree murder and they come in and they plead guilty to first degree murder so that there's no necessity of a trial, and they're sentenced to the mandatory sentence of life in prison without eligibility for parole for 25 years. That's quite unusual, but it does happen. More often, there is a discussion between the Crown and the defense about whether the person wants to plead to something lesser. Now, the pros for both the Crown and the defense really is certainty and finality. So if somebody is charged with first degree murder, for example, so you know if you're convicted what the sentence is going to be. But if the Crown is prepared for whatever reason, and there are many of them, to take a plea to say second degree murder, there is often an agreement between the Crown and the defense that the period of parole eligibility will be, for example, 15 years. So the obvious pro for the defense in that regard is they're eligible for parole 10 years before they would otherwise be if they were convicted of first degree murder. So now the benefit to the Crown and to the family of that sometimes trials are very long. Sometimes the evidence is only, evidence can be very strong, it can be very weak, and it can be everything in between. In our justice system, in criminal trials, you're only able to run a trial once. In our criminal justice system, you're only able to prosecute a person for a particular crime once. Now, that doesn't mean there might not be more than one trial, because there can be an appeal and another trial, but you can only prosecute them for the crime one time. It's the principle of double indemnity. Sort of that's actually an insurance term, but it applies in the criminal world as well in a slightly different fashion. So, for example, there were, years and years and years ago, before DNA science was developed, there were crimes that were not solved. I mean, it was many times the police were pretty sure they knew who had done it, but they just didn't have enough evidence. DNA was developed, and all of a sudden, the police could go back and they could do scientific testing on, find blood on a shirt or sheets or something like that, and they can test it, and they could determine that it was in fact the accused person as opposed to somebody else. And so that might be enough to just sort of go beyond the, well, a bunch of circumstantial evidence and sort of scientific evidence that this is in fact who was involved. Had those cases been prosecuted, say back in 1965, and the person was acquitted, was found not guilty, then even if the science was developed and we could now prove that they did in fact do it, we wouldn't be able to prosecute them again. So that's why we want to have really good, solid evidence before we take something to trial. And so if we have that, as I say, there's really good evidence, there's medium good evidence, and there's not so good evidence. And the Crown has to assess that and take a look at what is the likelihood of an outcome of either first degree, second degree manslaughter, for example. And sometimes what you'll do is the defense has got probably a pretty good argument on certain things. And so if they get their way, the likelihood the conviction would be for manslaughter. If everything goes the way of the Crown, the likelihood would be a conviction for first degree murder. So sometimes it's really a matter of meeting in the middle, a compromise position. And so we say, okay, we'll take a conviction for second degree, and then whatever the eligibility for parole might be, might agree on that, or it might be set by the judge. But so the benefit to the Crown is that there's certainty. You're getting a murder conviction, which is a life sentence. And that, I think, is really, really important. That, as I say, that means that regardless of parole eligibility, it means the person will be under the control of Corrections Canada for the rest of his or her life. So that's a benefit. The other benefit is finality. In our system, virtually every conviction on a homicide case is appealed. And I'm not sure what the statistics are for new trials being ordered, but they're higher than we would like them to be. And that's because it's a human system, and sometimes judges make mistakes. Sometimes the Crown makes a mistake about the evidence that's been put forward. Sometimes a witness will blurt out something that no one knew they were going to say, and now it's prejudiced the jury, and the Court of Appeal will say, no, that's made the trial unfair, you have to do it again. There's any number of things that can happen that would require a new trial. So that finality of a guilty plea means no appeal, no possibility of a new trial. So the big benefits of any kind of what's referred to as a plea bargain in sort of the general terms, for the Crown is finality and certainty. And then the benefit, as I say, for the defense is usually they're pleading less to something lesser than they would be potentially facing. So there's other possibilities in there, but those are the main reasons why there's resolutions.
Okay. And as you mentioned that if you're discussing the charges, first degree or second degree or manslaughter, in the end, it is the Crown's decision.
Yes.
Yes. So the family may want really, really badly to go for first degree murder. Of course, we hear that a lot of just, out of the desire for justice. And it's very hard for a family to swallow going for maybe second degree or even manslaughter. And I have communicated with individuals where they, of course, are expecting first degree because the person was apprehended. It's clear what had happened. It was a heinous crime, and yet they've come into our support groups distraught because a manslaughter charge had been communicated to them and delivered. And I can only imagine how tough that must be for the families to have to deal with that, and one more layer of helplessness that they
Yes.
feel, because in the end, as you said, it is your decision.
Yes.
So, and you mentioned you try to talk to families about that.
Yes, it's a very difficult thing for families, and I think it's really important for prosecutors to remember that it's important to try to explain why that decision is being made, if in fact that's going to be the decision. And most of the times by the time we get there, there's usually less concern about and interference with the integrity of either the investigation or the prosecution. So by the time we get to that point, we're usually in a position where we are able to tell the family some of the problems that we have with the case. And it may, as I say, it can be any number of things. It can be a witness who told the police that he or she saw A, B, and C, but by the time they're interviewed by the Crown, they've said, well, actually, I only saw A. I was told about B and C. Well, again, now we've lost that part of the evidence. So we've only got part of it. It may be that another possibility is that we're provided with proof of something else, like self-defense or drunkenness or something of that from the defense that isn't part of the initial investigation. So we have to balance all of that. And normally we can explain that to a family so that they will understand. I think part of the problem is that once the expectation is laid of a charge of first-degree murder, it's very, very difficult to understand why anybody would ever want to take something less than that. So it's hard to explain. I've had long talks with family members. I hope that most of the families that I've spoken to have gone away at least understanding, even if they don't agree. And that's really all we can do, is attempt to explain why we're doing what we're doing and have them understand what's gone on. So it's, I mean, and sometimes what we have to do is, it's an even worse decision is to make, is that we've decided that our evidence has just gone south and we just don't have enough evidence anymore to proceed. And I was involved in a case like that many years ago, probably 15, 17 years ago, where I had to explain to the family that the one person who had any evidence to give, there were many problems with his evidence. And if we went to trial on the basis of his evidence only, we were going to lose. And that would mean that they could stand on the street corner and say, I did it, and we wouldn't be able to do anything about it. So I did direct a stay of proceedings at that point, and eventually there's a group of police officers called the Cold Squad who investigate old cases. And some of those cases are DNA cases, things that they were able to find DNA on and get more evidence that way. Sometimes they use other techniques, and then they gather more evidence. So eventually that particular case was brought back to me. I think it was 12 years after I directed a stay of proceedings on it. And they had gathered some more evidence, and I looked at it again and thought, yeah, okay, we can go now. And eventually those two people did plead guilty. They pleaded guilty to, I believe they pleaded guilty to manslaughter, but I've forgotten for sure. But in any event, it was now a conviction. We now have people standing up in a courtroom and saying, I did this. And that was huge for that family. It was a very difficult pill for them to swallow when I said, we don't have enough to prosecute many years ago. So they were very happy, of course, when we eventually did get it back. So that's, that's a bit of a good outcome. Even though the original charge was murder, they were pleased that they had at least taken responsibility and were sentenced to whatever they got. And right. I've forgotten it again in that particular case.
Right. So it's finality, like you said, which I know is a relief for some families. Again, we hear that sometimes, they eventually they want to move on. And if that is indeed your recommendation, then they are then they do come around after after the explanations and the time that somebody such as yourself has taken, I do know that in our instances where we've heard about the families, that they do understand after some time and dedication to that explanation. So
I think as well that it's a matter of trust. If you've met with the family a number of times and you've explained to them what you can explain to them, and they've come to trust you, then it's easier for them to accept. If you're brand spanking new to the file, because maybe one of your colleagues has become a judge, or there's any number of reasons why files get moved from one prosecutor to another, and that's also, I think, really hard for families, and something that the Crown is aware of, and we try not to do that very often. But sometimes it's somebody retires, as I say, they could become a judge or something, and we have to do something. So again, it's important to build that relationship with the families and hear them. But at the same time, we're Crown Counsel. We're not the social worker. We're not the victim service person. We're not the best friend, and we're not the police. So it's a professional relationship, and it can be, made out of with kindness and compassion and all of those things. But at the end of the day, it is a professional relationship. But families do, I think, for the most part, come to trust the prosecutors, because we are pretty hardworking people, particularly when it comes to these kinds of cases. We take them very, very seriously. I don't know anybody who does this kind of work who doesn't work long hours, late at night, and on weekends and holidays and all the rest of it, to make sure they're ready for court when court comes along. And I think the families see that, and they come to appreciate it, but also to trust it. So when we tell them, this has come up and we don't have a way around this, so we think this is the best way to go, even when they're not happy with it, they generally understand. At least that's what we hope is the case.
Yeah. So tell me about the victim impact statement. I know you've said to me that that's the chance, whereas in the proceedings and the laying of the charges, it ultimately is your decision, but that the victim impact statement allows for the family to provide, what would you call, input or their experience about what the loss has meant to them?
Yes, it's actually it's a wonderful opportunity that not everybody takes up, because it's very, very difficult as well. So we hear from families quite often, this whole trial is about the accused. The victim has been forgotten. And that's a very, very sad perspective to have on it, but it happens to be true. I think I have to be blunt on that. The case is always called Her Majesty the Queen against whatever the accused person's name is, and it's about whether the Crown has got the right person with the right charge on, and in the right way, that has the right evidence. So it, by definition, is about the accused. It's about the accused's rights, whether the search was done properly by the police, whether he was given his charter warnings and rights, whether the statement was voluntary, all of those sorts of things. It's focused very much on the accused. But when a conviction is entered, that's when the family comes right to the forefront again. And the victim comes right to the forefront, because at that point, the family is given the opportunity to write a victim impact statement. And even on first degree murder charges, where the sentence is mandatory, it's still an outlet for the family. Is the opportunity for the family to come forward and provide information to the police about the emotional impact that this crime has had on them. It can be a physical impact. Some people are so badly overwhelmed by the stress and the grief, they have physical ailments that arise. There can be economic issues. If, for example, the breadwinner in a family is the one who is killed, and all of a sudden there's a spouse left behind and children, there's a huge economic impact. So all of those things, it's important for the judge to hear. On manslaughter, or even on second degree murder, where parole eligibility is going to be set for the judge, those can have a very big effect on the judge and what sentence he or she eventually imposes. There's rules around what you can say. It's not appropriate for a family member to say, I think the death penalty should be brought back and that's what should happen here. Or I don't care that this is only manslaughter. The person should get a minimum of 25 years in jail. That's not appropriate. But what is appropriate is this person was the love of my life. I will never have another Christmas, another birthday, another spring day without that hole in my heart being there. And those are very, very powerful words. So I have listened to many, many, many victim impact statements over the years, and I'm always really moved by the depth of the pain, and in many cases the ability to no matter what the justice system does, we can't bring back the loved one, the one that's been killed, but we can sometimes provide a sense that justice was done. And that ability to address the court directly is, I think, very important in that. So there's a number of ways that when you get to that stage where that can be done. So it's usually something that's done in writing, because we do have to look at it to make sure that the rules are being followed as to what is being said. Mm-hmm. So it's reduced to writing, but the person can read it to the court themselves, or the Crown will read it out, or it can simply be filed. If it's maybe there's some really important personal information that the person wants the judge to know, but doesn't want the media or whoever else might be in the courtroom to hear it. Most families do want the accused to hear it from them, though, so that they recognize that you might think you were stabbing another drug dealer, but that drug dealer has a mother and a father and perhaps a spouse, maybe children, and were well loved by whoever is the person's family or their friends or whatever. So I think it's really important for the accused to hear much of that, but so it's a balance, and that's completely up to the family to decide whether they want to stand up and read it out in court, or they want to have it provided to the court in another way. So that is an area where the family is in complete control over how they're going to have that information get to the court.
Yeah. And when you say that, some things are not applicable, they're not allowed to say, well, I think it should be this, or I think it should be that. Just being devil advocate, why not? There's a lot of emotions. This is a way for them to really tell you how you feel.
Because the criminal code sets out what the principles of sentencing are, and there are things like deterrence and denunciation and protection of the public. But deterrence is a different thing than retribution. So a revenge. So sentencing isn't about revenge. You've taken my, son from me, therefore you should never see the light of day. It's not an eye for an eye, tooth for a tooth kind of thing. There are very strong principles of sentencing that are set out in the criminal code, and the Crown Counsel Act provides that the Crown is the one who makes those recommendations, speaks on behalf of society as to recommendations as to what sentence would be, what the right crime is, that sort of thing. So while it's understandable that a person wants to say, I want this person, as I say, to never see the light of day, it's not appropriate because it's not based on those principles of sentencing. It's just based on a sense of grief and a sense of anger, perhaps, or a sense of wanting vengeance. Mm-hmm. And vengeance doesn't have a place. Retribution and denunciation do, but not vengeance.
Okay. All right.
Sometimes other things that will show up in victim impact statements is the anger, and the anger is understandable, but you can't say this is you can't use a whole bunch of swear words to say how awful this person is, because that's just not appropriate either. So those are things that we have to be careful for, and we explain that to people, and most people they try very hard to follow the rules, because everything else, like how it makes you feel, is absolutely fair game. I mean, it's not. There's no parameters put on that.
Okay. I want to back up just a wee bit in regards to the laying of the charges, and the fact that the police don't lay the charges, the Crown does. Explain why that's different in BC, and kind of and that does affect the time necessary, because the other comments that we hear a lot are, oh my, even though they identified who the person was the next day after the crime, it was 16, 18, 24 months before trial. So.
Right. Okay. So in British Columbia, well, in Canada, we have a criminal code, and it applies to every province and every person in Canada. But the way the Constitution is set up is the administration of justice is a provincial jurisdiction. So each province gets to decide how they're going to set up how justice is administered. In British Columbia, back in, I think it was around the early 1970s, we decided that what would happen is that Crown Counsel would make the decision about whether charges would be laid. So we call it the charge approval system. So the police do the investigation, and then it comes to the Crown, and we make the decision about what charges and who should be charged, et cetera. That's different than most provinces in Canada where the police lay the charges. And that has been reviewed numerous times, as recently as maybe 7 or 8 years ago, to see whether that's the system that continues to make sense. We think it does, and every independent reviewer has said, yes, this is a system that makes sense. And the reason is a simple one. Police officers are investigators. They're not lawyers. They don't necessarily know what the law is and how it's changing. We have a bit of a joke that the Supreme Court of Canada issues decisions on Thursdays. That the Supreme Court of Canada changes criminal law every Thursday in this country. Wow. So a police officer can't possibly be expected to keep up on all those nuances and those niceties. Mm-hmm. That's the job of lawyers. And so the police go out and investigate, they gather the evidence, and then it's up to the Crown to evaluate it and determine in British Columbia whether there's a substantial likelihood of conviction. So the result of that is, I think there's two really important results, is that there is a quality control filter on the charges that are going forward. And what that means is that in other provinces, the police lay the charge. Now a family this person's been charged with murder. A prosecutor comes along and looks at it, because at some point a prosecutor has to review it, regardless of who lays the charges. But if a prosecutor comes along and looks at it later and goes, there's no way we can prove murder here. The best we can prove is manslaughter. And then they change the charges, and now we've got people all upset and concerned. And Constable Bloggins over here says that this was a murder. Well, Constable Bloggins doesn't have a law degree and doesn't necessarily know what's going to happen in a courtroom. And it's no disrespect to the police. It's simply a matter of who's got what kind of training. I wouldn't know how to go out and investigate certain things, but that's what's not really fair that we would expect the police to be lawyers and lay charges. So, but the result of it is, in British Columbia, and again, I don't have the statistics at hand, but we have a very high rate of conviction on homicide cases. And the reason is because we're careful before we lay them. Mm-hmm. So we want to make sure that we've got the evidence, we've got the T's crossed and the I's dotted before we lay the charges. Sometimes that takes time. Mm-hmm. And sometimes it's a matter of the police going and speaking to witnesses, gathering surveillance information. There may be wiretap, search warrants that have to be executed. There could be an undercover operation. There's any number of things that happen, and that does take time. And that can be extremely frustrating for families, because usually at that stage, we really can't tell the family much about what's going on. So we have a family saying, well, we know it was Bob that did this, and why isn't he being arrested? Well, that's a matter of, as I say, the police gathering that information. And we can't say, well, don't worry, we've got Bob under surveillance, because we don't want Bob to learn about that. And all it takes is one person sending a tweet out or putting something on Facebook or saying something to their neighbor over the back fence. Okay, the police have got Bob in their sights. And then Bob hears about it. Well, that would be a very bad thing. So that's why we don't share that information with families. particularly when the police are investigating, or even later when we're prosecuting, because we don't want to, again, we test much of the evidence that the police gather with what we sometimes what we call holdback evidence, which is information that only the killer and the investigators will know. So if when the person's been arrested, they're making a statement to the police and they give those details, we know it's accurate and we know it's true and we know we've got the right person, because otherwise that's not something that is generally known. So
Right.
that's why sometimes it both takes longer, and why we want to be very, very careful before we prosecute. And the reason we want to be careful is, as I said before, is that we don't want to find ourselves with an acquittal and then sometime later more evidence come to light. We want to make sure that we've got everything there is before we put it forward. And the result of that is that there have been not a lot, but a number of notorious cases in this country of people who have been wrongfully convicted of horrible crimes. So particularly in Ontario and Manitoba and New Brunswick, I mean all kinds of, not New Brunswick, Nova Scotia. There have been people who have been tried and convicted of a crime, and then been found to be not guilty, been exonerated by DNA or something of that sort. So Guy Paul Moran and David Milgard and Thomas Sofino and people of that ilk. And we've had a couple of convictions in British Columbia that have been declared to be unsafe, but to my knowledge, there has been no conviction that somebody has been exonerated in a homicide case, has been exonerated by later evidence. And I'm convinced that one of the reasons for that is because we are so careful before we lay those charges.
Right.
So it's kind of a cost benefit analysis, and we think that, well, it's very difficult and painful for the family. At the end of the day, the families want to make sure the right person is convicted of the crime. They don't want to be having somebody serving a sentence for something they didn't do and have the real killer walking around free. No one would want that.
Great. So that's a fantastic explanation. And I hope that all of your information and wealth of knowledge can help people when they're viewing this, maybe understand why things are the way they are.